Welcome to this book discussion and launch of The Limits of Judicialization, From Progress to Backlash in Latin America. And I just want to start real quick and I say that, in spite of the title, the story of this book really starts with success. It's the success of courts becoming major political actors in Latin American politics, affecting policy outcomes and opening up possibilities for political contestation. Nevertheless, it must be said that the title asks, and the book in general asks, why do we see a continued disconnect between what we expect courts to do and achieve on the one hand, and what we see as real political outcomes on the other? And we're really fortunate to have the authors here today, Sandra Botero from Universidad de Rosario, and Daniel Brinks from the University of Texas at Austin. And we also have a fine panel of discussants. So Roberto Gargarella from Universidad de Buenos Aires, and then Marta Machado from Fundação Getúlio Vargas, Sao Paulo Law School. And then finally, Conrado, Hübner, Mendes from Universidad de Sao Paulo. And I will leave the floor to them and then moderate questions and answers. Thank you.
Thank you, Kyle. And thank you all brave souls who are here despite the heat wave. Please, if you have not served yourself coffee, go and do so now. We are so grateful for your presence and just very happy to have the opportunity to talk with you all about a book we've been working on for some time, and we are delighted to see it out in the meantime. I should also say that the third editor is Ezequiel, who could not join us for prior family commitment, but Ezequiel, we're thinking of you wherever you are in Argentina. So the Limits of Judicialization stems from a conference we held in Bogota in late 2019, where I had the pleasure to host an incredible group of people from across the Americas and the other side of the pond. We gathered to think about law and politics in Latin America. I'll start by telling you all we had a very different title in mind. We wanted to call it Broken Promises? ? Our editor was having none of it. She did not let us get away with any question marks, ambivalent titles, just like firm no. Probably wisely because she knows about academic indexing more than us. I'm bringing it up because that question is still a good opening to what the book does. We wanted to interrogate whether the promises that the judicialization of politics brought with it had delivered or not. Our book follows excellent volumes that have shaped the way we think about judicialization. The judicialization of politics in Latin America, cultures of legality, and courts in Latin America, which chronicled and analyzed the early moments of judicialization and how it unfolded in different countries and across issue areas and institutions. Judicialization, the transformation of politics in such a way that courts, lawyers, and prosecutors become key actors and the language and categories of the law become relevant concepts in politics, really broadened the horizons of what was possible in the search for social change and rights enforcement in the region. We have a lot of very important research, including those books and some of our own work, detailing the things that judicialization achieved, how it pushed rights and politics in new directions. But we think that in taking stock, we must also include the grays and the limitations. So the case studies, the different chapters in the book, give you a perspective of many ways in which judicialization fell short, backfired, or was thwarted, with a particular focus on Mexico, Guatemala, Colombia, Brazil, Peru, and Argentina. In the introduction, the three of us provide a framework that we hope helps us all think about why judicialization fell short and where it did so. In this brief presentation, I want to give you a taste of our argument and along the way, an overview of the fantastic chapters that make up the book and that we really hope you will read. There's actually a flyer in the back with a discount code if any of you feel so tempted. We say the judicialization project has fallen short for two main reasons. So first, because it made overly great demands on weak states and weak institutional foundations. And second, because it failed to generate the much needed social and political basis of support for many of the goals it was trying to advance. What was the goal of this transformation of politics? What is the goal we have in the region failed to reach? And so that we can say that the project fell short, right? What we mean by falling short is that the courts and the new emphasis on legality and rights, and also, but not only, litigation, failed to achieve the potential that was implicit in what we call the superstructure. And that in some cases, not many or most, the elements of that superstructure triggered some very negative reactions that actually threatened to make things worse. What do we mean by superstructure? We use the term superstructure to refer to the combination of formal institutional change and elite cultural change, largely credited for instigating the judicialization of politics in Latin America. So concretely, on the institutional side, things like constitutional changes, the creation of constitutional courts, the adoption of human rights treaties. Why do we call it the superstructure? The term is not at all meant to be pejorative, but simply to signal some level of disconnect between these changes and their socio-political context and their consequent political precarity. Something that's above, like a castle in the air. So here is the broken promise. The diagnosis is that the superstructure failed to achieve the promise that was implicit in it. Promises of greater rights recognition, greater adherence to the rule of law, less state violence, greater judicial independence, and more government accountability. Why? Why the failure? So the first problem is a weak institutional foundation for that superstructure, a failure to build state capacity. Examples. So some are simple failures of capacity. Janice Gallagher and Jorge Contes's chapter in the volume shows that even though Mexico has formally come to embrace sophisticated human rights legal standards as part of the institutional superstructure, local level judges and prosecutors lack the know-how and the incentives to translate those international norms and constitutional provisions into actionable bureaucratic templates. Sometimes the failures are in the courts themselves. In some courts, informal practices, deeply entrenched bureaucratic pathologies, and corruption interact with formal institutional facades to stunt the goals of superstructural reforms. So in his chapter in Mexico, Julio Rios Figueroa finds high rates of nepotism in the appointment process for the federal judiciary, which inevitably undermine efficiency and breed corruption. Similarly, in his chapter on Ecuador, Santiago Basabe Serrano relies on unprecedented access to legal elites to show that the concentration of power in the executive during Rafael Correa's administration led to soaring levels of judicial corruption in the Constitutional Court and a crippling of horizontal accountability despite the formal empowerment of the court. Santiago's chapter on Ecuador is really something else. We all wish that we could do that kind of interviewing because the stories that Santiago has on that chapter are crazy. The second problem is that there has been a general failure to build a social base of support for judicialization. So this second problem has different dimensions, and the chapters explore some of those dimensions. So first, the progressive normative content of the rights-spanning component of the judicialization project has often been out of sync with social norms in the region, in a region where socially conservative values are still predominant. So going against the grain to protect rights can raise serious problems for institutional legitimacy and for the acceptance of specific decisions among the public. The chapter by Forero and Rodriguez Raga explores the effects that different types of arguments have on support for Colombia's institutional court and how that court builds legitimacy and as a way approaches that central problem. Second, the growing NGOization of progressive social movements has meant, in some cases, the detachment of rights advocacy organizations at the forefront of progressive social legal mobilization from grassroots movements. This is a problem we have spoken about in some of our sessions before. So as Camila Llanella's chapter shows on Peru, Camila in the back, sophisticated legal advocacy efforts around sexual and reproductive rights have achieved key international victories. But on the ground, rights realization is blocked. Alba Rival's chapter compares the counter movements against abortion in Latin America, challenging us to think about how counter movements on the ground can be beyond backlash. Or in the case of Guatemala, with the CICIG, we find an institution that pushed for corruption accountability with key backing from outside actors, but was perhaps too insulated from its content, which is what Rachel Bowen shows us in that chapter. A third dimension of the lack of social support is resistance from powerful actor. Laura Bernal chronicles the worrying lack of accountability of grave crimes for business actors in the context of Colombia's HIP, the transitional justice system. While in many instances the superstructure had a tenuous impact on social reality due to these difficulties, it sometimes worked exactly as expected. And in a few occasions, it did so perhaps too well. As a result, what we also find is that some forms of judicialization violently crashed against reality, and they wreaked havoc on the political order, threatening to undermine the very same institutions that made them possible. This clash is clearest in the corruption cases that have rocked the politics of Latin American countries, best exemplified by Lava Jato in Brazil. Here we witness the creation of new accountability institutions and empowered new actors, especially prosecutors, to police the exercise of power. But this new emphasis took place in the context of rampant corruption, compromised judiciaries, and compromised prosecution services. The superstructure clashed with reality. 4 chapters in the book show that judicial agency can also contribute to backlash and broken promises. The chapter by Darros and Taylor shows how Brazilian judges and prosecutors profited from the new tools and institutional structure created by superstructural reforms and used them to take on the political class. The chapter by Rodriguez Machado and Mota Prado, Marta, they explain in their chapter how prosecutorial zeal, coupled with the difficulties they encountered when trying to investigate deeply entrenched corruption, induced judges and prosecutors to overstep their prerogatives and undermine due process. Viviana Baraybar and Ezequiel show that prosecutors embraced innovation and controversial prosecutorial strategies in Peru. And they also document the dynamics of backlash engendered by the criminalization of corruption. For us, this is definitely a half empty, half full scenario. We do not claim, nor do we want the conclusion to be that judicialization has been a disaster or has left the region worse off. But we think that looking at the shortcomings is important to think about how to address them going forward. We want to open a conversation. We know that the book leaves some questions unanswered, raises new ones, and creates a space for other conversations, which is what Dan will speak to next, very briefly, to close.
Thanks. Thank you, Sandra. And I guess I want to start with a word about the process. One of the greatest things about this project was working with all these scholars from Latin America. Most of them are either from or currently in Latin America, and they're people who know the politics of these things very closely, and they've been often involved personally in the processes they're describing. And we learned a ton as a result of the collaboration. So the book is really a collaborative effort. And it was also an enormous pleasure to work with 2 young colleagues, Sandra and Ezequiel, who at one time were my students, and now they occasionally teach me things. So that was really wonderful. And I guess the one thing I want to say, we've been playing around a lot with this notion of pessimism and optimism, and I think the book was born out of pessimism. When many of us started working on courts and litigation and so on, we thought, wow, there's so many wonderful things happening. There's so many great things, and maybe they won't, get as far as we hope or whatever. But there was interesting stuff happening everywhere. And when we sat down to do this book, wherever you looked, there was reason for pessimism, and there still is, right? I mean, we haven't kind of gotten out of that moment of pessimism. And I guess what I will say to Lisa is that we had Berta Cáceres once visiting us in UT, and she said, well, what you need is you need pessimism in your head and optimism in your heart, because otherwise you give up. And then, of course, she was murdered shortly after that. But I think that's still true. So the question, I guess, for us as we look at the various chapters in this book and thinking about this is really, can we really say the project has failed altogether? I think the idea originally was that these institutional innovations, these new constitutional frameworks, these new ways of doing politics and mobilizing and gathering social movements were going to do a number of things. They were going to empower underprivileged groups. They were going to bring excluded voices into the public sphere. They were going to, in a way, animate, give more strength and more voice to people we hadn't listened to in 200 years of Latin American democracy. And clearly, there's still a lot of room for pessimism, but there are some things we could identify. There are ways in which we see greater respect for rights. We see more dignity for LGBTQ people and others. We see, and the indigenous I think are better off in some cases, and women are better off in many cases, and so on. There's some protection of health rights in different places, and so on, right? So the question, I guess, for all of you is, what do we do now, right? In light of where we've been, in light of the fact that in many ways we have failed to kind of ground these lofty aspirations in real social movements, in real conversations, in ordinary politics, right? How do we do that? How do we get the superstructure more deeply and fully anchored in stronger institutions and more robust systems of social support?
All right. Thank you, authors. Now let's turn it over to our first participant, Roberto.
Thank you. Well, first, I'm extremely honored to be here, and this is not just to please anyone, but it's really, I have admiration for all my colleagues here, and I think that the book is an expression of how I think academia should be done. I mean, in the way of you see a problem and you are concerned about that problem, and that problem is publicly important, and you follow your thoughts about that, and you try to do research on that. So first of all, express my admiration for the project, and I had the opportunity just to read a little bit the introduction of part of the chapters, but I got an impression of the book. So I have a few comments, but some are doubts and genuine doubts, and so I want to ask the authors. I want to use the opportunity to ask them some questions and then maybe suggest something. But so I have basically 3 comments, which are 2 of them are questions. So the first is perhaps because I couldn't read it properly, or I couldn't get the entire picture, but about the standard of evaluation. So in the idea is that the book evaluates the practice. I mean, thinking about the goals established by the provisions or constitutions, or and that I don't clearly understand. First, because sometimes I mean, from the text, you cannot derive what is the purpose of the text normally. And second, because in many cases, we know, and I don't want to take the cynical view, but in many cases, say, rights are included because of the wrong reasons or the bad reasons. No? So, for example, in Rosalind Dixon's rights as bribes, rights are included, not because they want them to be enforced, but they want to be used to bribe certain groups, etc., etc. Or in many occasions, and this I think has been the case related to some of the best experiences in the region. So I'm thinking about what I learned from, for example, I think from Bruce Wilson in Costa Rica, or from the practice of the Constitutional Court in Colombia, that these institutions, in a way, appear to work in ways that were not expected. So they were unintended consequences. I mean, I remember, I think, the article by Bruce about how the Sala 4 in Costa Rica was incorporated in the Constitution, and just for I mean, whatever reasons, and then it appeared that it was working in an interesting way. So first question is about that, no? So because also I'm biased in the sense that I tend to evaluate text from say, an external theory, independent theory. So this view, I mean, where is supported and where it takes us. Second is about some of the conclusions that Sandra now was mentioning. So, and that I tend to share some of the things I read and some of the things that Sandra said, but I think that there are some differences that should be emphasized. One is, so for example, you mentioned, Sandra, and it's mentioned in the introduction, the problem of weak state capacities and the lack of social connection with grassroots organizations, etc. And I think those are important problems, but important problems for what? So that are important problems, for example, for the enforcement of good decisions, but it's not that, I mean, one of the problems we have is that we are not going to get, under these conditions, the kind of good decisions that we want or we demand from judges. So for example, regarding the weak state capacities, well, I don't know if it's weak state capacity because it may be stronger, but the problem will still be there because I think, for example, in many of these institutions have been designed in the wrong way. So we cannot expect them to produce certain kind of results. So it's not a problem of the weakness of the state, but it's a problem that the means are badly designed. So in that sense, I think that the reasons of hope we may have to do with a proper diagnosis. And this, so I want to explore and I want to ask you about the precise meaning of these two initial conclusions. So again, I think that it's not a problem of a weak state, but in part it's a institutions that have been designed in the wrong way. And the final point has to do with this. I think that under present conditions, under present institutional conditions, as I said, we cannot expect from judges the kind of decisions that we, academics from the left or progressive scholars, would expect them to produce. And so again, it's not just a matter of implementation, but it's a matter of creation of these kind of decisions. And so I always go back to this Madison understanding of the Constitution, that he was saying basically the main advice about how to design a Constitution, you think about the means and the motives, not the constitutional means and the personal motives. And so if you provide the proper institutional means and you ensure the proper motivations, then you are fine. If you don't do that, I mean, you are doing the wrong design. And I think that under present conditions in Latin America, what we tend to obtain is what it appears, for example, in the chapters by Julio Rios or by Basabe in Ecuador, which is also a fantastic chapter about Ecuador. And so what we obtain? Well, we obtain judges that during a long period of time, these what seemed to be the amazing new constitutional court in Ecuador, well, it was just, at the service of the president. And this is not an anomaly. It's not a pathology. No, it's an institution that was badly designed. It's an institution where judges have the power to do whatever they want, including obtaining incredible privileges or benefits, and they have the motivations for doing many things, but first of all, to serve themselves. So under those conditions, you have enormous benefits in the front, and then you have the wrong motivations. Well, of course, you are going to obtain that, but that's, among other things, a problem of institutional design. So the idea is, those kind of chapters, for me, would have suggested a different conclusion, or I would emphasize other things, but maybe it's just a matter of nuances. So it's not that I'm making an objection. I'm trying to learn, the precise content of the book, because I couldn't have the opportunity to read. But so my final conclusion is, or initial conclusion is that the book, from what I read, it's a great contribution to a discussion that was, I would say, stuck or was placed in the wrong place. So we learned a lot. We got a lot of incredible new information. And so thanks for the contribution to all of you.
So first of all, I'd like to thank Dan and Sandra and Ezequiel for the honor of being part of this groundbreaking book, and also the Bag and Exchange, because the invitation to take part of the book, in fact, came from the discussion we had in the 2019 Bag and Exchanges, where we had a session on corruption, and we discussed all that, and then invited me to that book. So I wrote my chapter with Mariana Prado from University of Toronto. She is the anti-corruption scholar, and I, because of my background in criminal law and my research on social movements and law, the role of law in political contestations, so that was my point of entry and our partnership to do a case study on the Lava Jato. In this discussion, the Lava Jato case is an interesting case because it was a turning point in the Brazilian discussion about judicialization in Brazil. So although there were several more ambivalent diagnoses about judicialization, and some voices like Conrado, like the studies on health litigation that brought more ambivalent assessments, there was a very optimistic assessment to the judicialization in general. But the Lava Jato, started to change that view. And it also brings another kind of assessment addressing lower instance corruption cases and direct impact of the judicial system in the electoral politics. So, as you know, Lava Jato had, and as you discussed yesterday, Lava Jato had a huge scope. It involved the Brazilian giant oil company, Petrobras, the largest construction companies in the country, and several high-ranking politicians, and had profound economic and political consequences to the country. So focusing on the political impact, among the more or less 300 people who were criminally charged, 50 of them were politicians, including the then president of the Senate and the then president of the House of the Representatives, and 2 former presidents, one of them being Lula. Lula was sentenced to 12 years in prison in a conviction that was eventually nullified by the Federal Supreme Court, but prevented him from running the 2018 election when he was the front runner at the polls. The operation also created the conditions from the impeachment of Dilma Rousseff president, although corruption was not the legal basis for that. And it also fueled a huge anti-Workers' Party campaign, which was essential to the election of Jair Bolsonaro. So in this chapter, we focus on the issue of publicity and the relation between the judiciary and the media, opening space for dangerous dynamics of penal populism and undue interference of the judiciary in the political arena. So Lava Jato has resorted to publicity in unprecedented ways. So all documents of the case were available on the internet. They were drafted in clear and accessible language. As you know, it's not the rule in the legal field, but also allowed that journalists could extensively make use of those documents and more or less controlled the version of what was there in the media. The prosecutors of the case were giving regular press conference to journalists, but our claim is that, so that was all in the sake of publicity, transparency, public interest, but our assessment is that publicity was also genus-faced. So while it increased transparency, and it was also a strategy to protect the case from the influence of the political power, it raised many tensions. So it affected human rights, damaging human rights of the accused, damaged the image of the individuals and presumption of innocence. It caused irreversible political damage, and it was also used by judges as a tool to influence partisan politics and the ballot box. So in the paper, we discussed three instances where that dynamics comes out. I will just point out two cases that just to give you an idea of what kind of dynamics we are worried about. And we also discuss how our instruments fell short to control this kind of dynamic. So the first example that we discussed was an audio release of a sensitive conversation between Lula and then President Dilma Rousseff, and Judge Moro, the leading judge of the case, decided to publicize an audio recording of a wiretapped conversation between Lula and Dilma regarding Lula's nomination to become a minister in Dilma's cabinet. So the conversation was edited in a way that suggested that the reason of the appointment was to grant Lula the special jurisdiction of the Supreme Court, and then it would be a scheme to flee Judge Moro's jurisdiction. So releasing the audio was blatantly illegal. I don't go into the details, but there is a clear obligation that the judge should keep the content of wiretapped content in secrecy, and the audio also involved the president, so he should have sent the case to the Supreme Court. But while he had no support at all in the existing legislation, he justified his position in the sake of public interest and transparency. He was called in by the Supreme Court to give explanation, and at the moment he just said, "I give my profound and respectful apologies." And basically nothing else happened to him. A disciplinary process was open against him in the National Council of Justice, but was never proceeded, and it was never judged. And many analysts say that the reason why is that at that moment, Judge Moro, because of all his engagement, and the Lava Jato Task Force, because of all their engagements with the media, it was very difficult to the Supreme Court to sanction him or to stop him. So okay, my time is coming. I have another case, so I don't go further in this. But what was explicit, I don't know if you know, there was, after a while, the independent media outlet leaked in private conversations between the task force members, and two things came to light. First, that the conversation was edited, and in fact, the other parts of the conversations really suggested that there was real political motivation for the nomination. Lula was supposed to rebuild the basis and prevent impeachment, and he was even fearing that that movement would appear as a way to flee Lava Jato. And the second case is that the prosecutors were really balancing although they knew they were doing something illegal, they were balancing their popularity. So it's a legal minor detail, and we have a huge popularity, we have a huge support, so probably nothing will happen with us. And so to be very short, the second case is still more problematic, and it refers to the release of a very sensitive document by Judge Moro in the eve of the first round of the 2018 election. So the document was the plea bargain agreement of Antonio Palocci, who was former Minister of Finance of President Lula and Chief of Staff of former President Dilma. And he tried to negotiate a plea bargain agreement with the public prosecutors, and it was considered very weak. So in the Intercept, they were all saying he had not a novelty to discover. Everything he had to say, one could either find on the Google or had no evidence. And Moro was fully aware of the fragility of that document. So the deal with the prosecutors didn't work out. Palocci went to the federal police to do the deal there, which is allowed. It's a complicated thing, but is allowed in the Brazilian criminal procedure. And he successfully obtained the deal. And then that's a very tricky thing with the timing of what Moro did, because the deal happened in April 2018. It was sanctioned by the judiciary in June 2018. And then on the 1st of October, 6 days before the first round of the election, Moro, acting in his own initiative, decided to add the document to the Lula's file and make it public. So the document was, of course, a political bomb, and it was massively explored by the media and by the oppositors. And I think the trickiest thing here is that although the timing was clearly malicious, he was not doing anything illegal, because Brazil has a mixed inquisitorial criminal procedure model, so the judge has autonomy and discretion to be active in the process. So I think I think that Lava Jato gives us like many food for thinking on the challenges and risks of political uses of law enforcement, especially anti-corruption law. And also it shows, I think this instance shows the challenge to regulate the relation between members of the judicial system and the media, especially on those gray zones when judges can interfere in the political process with very subtle attitudes via releasing specific pieces of information and timing decisions to minimize or maximize electoral impact. So I'll stop here.
Well, good afternoon. Happy to be back here. It's an honor to be part of this panel with such highly admired and respected colleagues and friends. I also had the opportunity to read the excellent and long introduction and see bits and pieces of other chapters. And I had more than comments. I have a few questions that perhaps resonate and could organize how Dan and Sandra can tell more for us about the book, which I'm really looking forward to read, as much as I'm looking forward to read Roberto's book, Ruth's book, Lisa's book. There has been many book launches, and we are flooded with reading tasks for the next couple of months. But I have four very, very straightforward points. Starting with the very idea of the title of the book, Limits of Judicialization, and you spend several pages trying to calibrate the benchmark of success and failure, and trying to be fair. So you state that there is something new in the way of making politics. Courts brought that new channel, turned our delegative presidentialism much less delegative, created a new channel. And the trigger, the founding moment, basically the constituent moments between the 80s and 90s were basically increasing the power of courts, increasing their autonomy, expanding the repertoire of procedural tools and channels, financial autonomy, and also a new mode of thinking about the role and about the role of law and how to interpret it. So the driver of judicialization was this institutional superstructure, and the obstacles were what you call the infrastructural support, which includes social, political, and bureaucratic. So the first question that came to me is, 30 or 40 years on, in retrospect, with the benefit of hindsight, how could they have done differently in order to avoid these mistakes? What else could be done in terms of those given foundations? And what occurs to me that there hasn't been much thinking, or at least for those for the engineers and the architects of that phenomenon, there hasn't been much thinking on who the judges are, for example, on the absence of decent governance mechanisms. There were no ethical, no clear concern about the ethical regulation of their behavior, their conflicts of interests. And it occurred to me a few concepts that could perhaps play a role. And this very much connects with what Roberto mentioned regarding the difference between weak state and bad design. And the bad design is not the weakness of bureaucracy, it's the bad design of the courts themselves, which I don't think is what you mean by weak state. So the first concept that came up to my mind, and this concept, I use the Control F, the benefit of having a PDF. You have this without much time to read it. You use the Control F to locate a few expressions, and corruption is something that came up in several chapters. It is connected with nepotism, etc. And I wonder whether the very notion of judicial corruption is sophisticated enough to capture several kinds of behaviors apart from enriching judges, the quid pro quo traditional notion. So this is one thing. Perhaps that there is something in judicial corruption, and I know the book, several chapters of the book mentions it. Another notion is what I would say I would call judicial elitism. This connects with who the judges are, but two other notions which I think are important to look at the Brazilian judiciary, and certainly for other Latin American judiciaries, which are judicial populism. Lava Jato is a great case of judicial populism, but it's much broader than that. And judicial authoritarianism. And when I say judicial authoritarianism, I'm not referring to a more common way to think about the judicial role in authoritarian regimes, how they get instrumentalized, etc. I'm stating something which is independent from the regime itself. It's independent about the autocratization process. It is authoritarian practices in themselves, and the lack of control for that. I'm not sure that these notions could help translate in another way what the book already is arguing, or whether it could add some new angle. This was the first point. The second is the book puts together two very different kinds of judicialization. One is the fundamental rights judicialization, and the other is anti-corruption judicialization. My impression is that these are two very different animals, triggered by very different forces and motivations, which might make tricky to put under a general heading of judicialization. And I wonder whether, well, of course, both are phenomenon of judicialization, but I wonder whether I don't have any position and any answer to that, whether how the difficulties, the methodological and analytical difficulties there were for the authors to consider in a book that wants to look at judicialization in Latin America, to make the fair distinctions between two things, and how to put the both things under the same umbrella. I'm not sure if I'm being clear, but just the impression that these are so different things that the whole explanation and the whole story might be different. So there is this first risk of generalization, to put these two very different animals under the same umbrella, and of course, let me raise a very common question about any effort to say something about this very general concept called Latin America, and I wonder, one common objection which might or might not apply to this book is, well, it overlooks important differences, which means that it can be quite difficult to draw general conclusions about this very broad phenomenon called judicialization for the whole region. That there are very good answers to that question, but I wonder whether you could tell us something. And finally, about Lava Jato, it's just a comment, because it was an anti-corruption judicialization driven in a very messianic, anti-political and populist style, and perhaps it is not the single cause, but it has facilitated or helped galvanize autocratization in Brazil. Some like to say that there wouldn't be Bolsonaro without Lava Jato, and of course things are more complex. But this account, despite being reductionist, is not too unfair. And the Lava Jato was faced and was confronted through the reaction to Lava Jato was also very strong, and was confronted through a rhetoric of decriminalizing politics, which responds to the accusation of the criminalization of politics that Lava Jato supposedly practiced. And this reaction to Lava Jato was a very successful political and especially lawyerly strategy to combat Lava Jato. So Lava Jato was itself, can be said to be in itself a backlash against a handful of left-wing policies applied by the previous government. And then Lava Jato itself faced another backlash, which paved the way, not only paved the way for Bolsonaro, it paved the way for the most corrupt political forces of the country to dismantle anti-corruption infrastructure, which we are seeing today. Brazil is much less prepared to face corruption in 2022 than it was in 2015. So it was so tragic that we might wonder what the role of judiciary in this whole process was. Thank you.
Authors, would you like a moment to respond before we go to Q&A? And the microphone is over here if you'd like to start lining up.
Okay, thank you for the generous comments. Very briefly, because I want to make sure that we have time for to hear from the audience. I think I'm going to try to speak to two of Conrado's questions and comments. So the first one is, with the benefit of hindsight, what could they have done differently given those foundations? Let me talk just about one thing of the many I could speak, and this is obviously my personal bias given the stuff that I study. To me, it seems absolutely central. We're looking at legal operators beyond just judges, right? And from the work that I've done and from what I see throughout the region and from many of our discussions when we were in the workshop and with the people, the kind of work that happens with grassroots organizations, from legal advocacy organizations, is crucial and was missing in many countries. So for example, this is the big problem that Camila chronicles in Peru, and this is the problem that early elite abortion activists had in Colombia. That there was very high level litigation, a lot of work done in the universities, and no work initially with the grassroots organizations, which decoupled. And so I'm giving just this example to suggest that that kind of work was missing in many cases, and it is absolutely fundamental. That one, to me, that kind of rethinking from the legal actors is crucial for the first one. And then you're concerned that perhaps it's even too much to talk about Latin America and to do the comparison with the whole region and across these two very different kind of monsters. It is in the sense that one is rights judicialization and the other is the corruption problems. This is a question that I also grapple with when I'm thinking about the book and about other projects. But it seems to me that this kind of work is essential, not because it can capture the richness of the particular of every country, but because I do think there are big things that we can learn from the patterns, right? Even just from looking at the different experiences of lavallatos in some of the countries, compared with, for example, the difficulties that the prosecutors or the limits that the prosecutors face in places like Mexico and Guatemala. So I think there are important connections there. So I don't think and I'm sure this is also the case with Dan and Ezequiel, want to do violence to the specifics, but I think there is a worthwhile effort in at least trying to throw the broadest lines so that we can glean some regional reflections from those. And because I said I wanted to be brief, I will shut up now. Done.
Okay, thanks. So thanks again for all the great comments and the probing questions. I think the questions are the best part of these events. And so let me say something really quickly so that we can get to the audience. The first thing is about the standard for evaluating, right? How do we take stock 40 years in of a phenomenon that is so varied, so rich, there's so much going on. And we struggled with that a lot. At the end of the day, we came down to thinking to a couple of things. There were a couple of things we didn't want to do. So the first was we didn't want to judge what had been accomplished against whatever the secret purpose was of whoever was involved in writing some document somewhere across the region, right? So that it wasn't that. It wasn't the sort of secret intention of the drafters, whether they were hypocritical or whether they really meant what they said when they put it in the document. And we also didn't want to measure what had been accomplished against some sort of utopian standard, right? So we didn't want to say, well, you said there was a right to housing. There are people who still don't have housing. You failed, right? So, so in a way, right, what we thought the effort was, as judged more or less by the public purpose of the documents, right? But also by the writings and the self-understandings. Because remember, the superstructure as we describe it has two elements. It has the textual element, but also this sort of cultural shift that was described by Rachel and some colleagues in a book and so on. And we thought that the goal was largely to generate a new kind of politics, right? And the goals were going to be the output of those politics. But what we really wanted to see was the extent to which sort of that politics had actually taken root and been able to thrive. And you know, it's a collaborative project. A lot of people submitted lots of different papers, and there's a lot packed into a little. And then so there is some overgeneralization at times, but I think, you know, more or less, I think we were able to apply that standard, including to two phenomena that are really different, right? So like the anti-corruption efforts, which are sort of the criminalization of certain behavior, and the mobilization for basic rights, which is the other big phenomenon. But we couldn't, when we said let's take stock 40 years in, we couldn't ignore Lava Jato. We couldn't ignore the wave of anti-corruption efforts, and if you trace them back, right, you can trace them back to related origins, right? So many of the documents, the Colombian one in particular, right, which we often think of as this very rights-rich document, has huge elements of sort of law and order, rule of law, empowering prosecutors and so on. The 88 Constitution in Brazil, the same. It empowers the Ministerio Público and gives it powers that I think were unprecedented in the region at the time. And that's similar, I think, to the impulse that led to empowering courts in unprecedented ways, right? It was a way to sort of relocate a lot of the contention into these specifically legal spaces. And so I think it's fair to put them together. You know, I mean, sure, they're different. Of course, they're different, but I think it's fair. So that's the first thing. You know, what's the standard for evaluating this whole thing? The other question is that I want to highlight is this question of like, well, was it just, did we pick the wrong institutions? Did we pick the wrong tools for the job? Is it the design of the institutions that's wrong and it's not state weakness? We separate those two things, and we actually have a pretty strong critique that I think Roberto might be sympathetic to, of institutions that are designed to be insulated from society and insulated from politics, right? And what we say is, look, if you want institutions that are more autonomous, don't try to build moats, you know, dig moats and build walls around them to separate them from politics, because that's a fool's errand, right? I mean, what you have to do is really build sort of inclusive and pluralistic connections between these institutions and society. And so when you look at institutions like the CC in Guatemala, which is very much a product of an international effort and a very elite thing, or like the Ministerio Público in Brazil, which was also so, you know, really designed to be independent, you know, in the sort of USAID World Bank notion of what that meant. That's I think where the problems come in, and the same, you know, unaccountable judges who, once they're in their spots, they can do whatever they want, right? So we're critical of those design choices, and you know, in other work, I've done stuff on what I think are better design choices, but I think there's a difference between that and state weakness, like the sorts of things that were pointed out in Mexico, where it just, everything falls apart at the ground level with police officers who don't know what they're doing, prosecutors who don't have any resources, judges who aren't well trained and well resourced.
Okay, I've been overruled. We'll take 3 questions at a time.
Oh, you take long.
Oh, we'll take all of them. I've been overruled again.
All right, fantastic panel. This looks incredible. I just wanted to pick on a bit of this institutional alternatives debates. In a way, those anti-corruption investigations, they were fueled by a deep mistrust on the political system to actually reform themselves and bring about more Republican ideas to life. And now we look at the abuses, oversteps, missteps, and with a general mistrust on the capacity of the judiciary to actually implement changes. So to a large extent, and in many countries in Latin America, there's this comeback to the fact that grand corruption should be dealt by politics, with no big judicial pushes, and incremental changes should be preferred. This may not answer to much of the population's aspirations to republicanism, and may actually fuel the ideas of democracy being discredited already. So how do we leave these kind of traps between politics and judicialization? How do we reconcile republicanism and democracy in a way? Yeah, thank you.
That was a big question. I'm looking forward, of course, to read this amazing book. It looks like great. And so I have some questions that probably you write about that in the book, but I haven't read it yet. And so one is, you talk about weak institutions in Latin America and weakness of some sorts, institutions, state capacity, grassroots work. And I was thinking about a kind of backlash in North America, you know, like think about abortion and things like that. And I was wondering, is it a different phenomenon? Or is it the same? Are we talking about like different weaknesses? And the thing is like, well, you know, like there's always this tendency to talk about weakness in Latin American or South, global South institutions and think about North, the global North as a space with stronger institutions. And we still see in those countries limits of judicialization, backlash, and so I was wondering whether there's something there. And the other thing is my question is, weren't we warned about the limits of judicialization from the very beginning? Think about like, I'm thinking about like juristocracy and things like that, that said us from the very beginning, don't trust that much, you know, the courts. And was it ingenuity from our part, or do you think it was a mistake, or what was there? Thank you.
Thanks for the presentation. Looking forward to read the book. I have two short questions. This one is, I think it was kind in the air, but when we talk about the limits of judicialization, does this reveal the limits of judicial review? Is it related to that debate? And when you talk about the limits of judicialization, I was thinking, so what court can do for individuals at the end of the day? And I was thinking there more on the theory, whole theory for the theory of absolution, the whole book. So I was thinking more on that line, that maybe courts, maybe we are too ambitious, what social, you know, changes, but maybe what court can do at the end of the day is like take out, you know, sanctions from individuals rather than this big things movement that we may want at the end of the day that they do. Thanks.
My question is based on an assumption, and they say assumption is the mother of, so please just forgive me if I get there. It's judicialization of politics, and you're doing a comparative of different countries. So my question is, are there countries in Latin America that have not judicialized their politics? And if there are, what are their experiences that is different from those countries that you've studied that have judicialized their politics? Do they enjoy a politics that is so different from the backlash that the judicialized countries are experiencing at the moment?
Okay, last quick question. Thanks very much for your presentation, which made me think about that as limits of judicialization started to become more and more evident in the past years, as probably the chapters show, and as social legitimacy of the judiciary has started to erode, like very evidently as well, at the same time, judicialization of conflicts is still a thing, and people tend to turn to courts in order to solve political or social conflicts of many different matters. So do you think that therefore there's some tension there, and there needs to be some explanation to these two phenomena coexisting? Thanks.
Please, try to get comfortable. Yes.
Right. So some things I think are easy answers that require long explanations later, but maybe we can keep the conversation going somewhere else. So, you know, what of the U.S.? Is the backlash different in the US? Would we attribute different causes, or do we think that weakness is a feature of the global South and strength a feature of the global North? The answer to all that, I think, is just no. I think a lot of the roots are the same. A lot of the causes of different phenomena and problems are very similar, and I don't think that these things are only happening in the global South. So there's been a lot of critique of the sort of litigation for social change in the U.S. and we're really familiar with that. What we're talking about here is different, right? It goes beyond litigation, but I think there's a lot of similarity. Andrea asked if we're maybe asking too much of courts. I think, right, that's what we didn't want to do, right? We didn't want to say, well, you didn't change the world, you didn't create utopia, and so you failed. And I think the chapters pretty much stay away from that, right? What they do is they show the ways in which particular social groups sort of fail to translate initial successes within the judicialization realm into outcomes or the ways in which even the effort to use these new tools were frustrated by things like institutional weakness at the very base level, or by judicial corruption, and so on. I mean, there's interesting research coming out now about why people turn to courts, even though they can see that the courts are not really good answers. And I think that sort of the answer to that question in a way captures a lot of what we were trying to show in the book, which is people turn to law, courts, rights for political reasons and in political ways and as parts of political movements. And when they do so, when they have ways of attacking their problems that incorporate rights but don't rely exclusively on rights and elite instruments, then they're more likely to be successful. And there are a number of countries and a number of issues and a number of spaces in Latin America where this approach has been successful. So one of the things we really try to do in the book, which doesn't come out when you give the nutshell version, is to acknowledge that there have been important advances and successes as well. The big one, Raquel, on republicanism and democracy. I mean, you know, the challenge, I think, and this I think is not, we don't really talk about it very much in the book, but I think it is something that we could have said a lot about, and that is, you know, there was a critique. And there have been sort of longstanding critiques of sort of rights-based activism or legally based activism or judicializing conflict in a way that it's disempowering, it's domesticating conflict, it's really kind of transforming it into legal categories and legal venues and handing it over to legal professionals and so on. And I think what the book actually does, to the extent it does anything, is to show that that's the wrong approach and that does lead to failure, right? If there is a sort of animating ideal behind the sort of shadow referent about what might have been different if people had done things differently, it would have been, look, spend a lot more time doing the kind of grassroots politics that are needed, spend a lot more time worrying about whether you have the political and social support, spend a lot more time thinking about, you know, where your demands are going to land and who has to respond to them.
2 minutes overtime. Promise I won't go beyond that. So this is going to be really flash. Nicholas asked, Nicholas, yes, whether there are countries in Latin America that have not judicialized and what is different from their politics. I am going to risk a gross overgeneralization here. Conrado, please don't hate me. I am going to rely on this idea of the superstructure in the 80s and the 90s, right? So the things that changed in terms of the institutional structure and the cultural changes high up. My big sense is that the places where less of that change happened had a rougher time at judicialization in the years that followed. This is not an iron rule, right? But where some of those, again, where some of those big, ambitious reforms that set off at least different discussions, we got less of that, then we saw less judicialization later on. Or perhaps it was forced, and then that had other problems. For example, in some of the countries in Central America. Just to be very brief, happy to talk about that more. Second, Andres asked if there was a tension between judicialization and the failures coexisting. From my perspective, none at all. It seems to me like part and parcel of ongoing social and political structures for these things, partly because I think a lot of our discussion here focuses on the pessimism, but we are not thinking that the whole story is a disaster. Like, it has actually worked for some things, if for nothing else, to change the conversation. But in many areas, we can actually see improvements and important changes. So the fact that people keep turning to this suggests that it is important because, again, if nothing else, a change in the narrative, which is something someone said in this earlier panel, and I thought that discussion was also very powerful. And finally, Natalia asked if Rand Herschel hadn't warned us about the limits of judicialization from the beginning. Like, no. I mean, I think clearly, well, that is a wonderful, thought-provoking book. It is also a book that is very limited in its understanding of what impact can be. And we really, really, really need to move beyond that assessment and that discussion. I think the reality of thousands of people in our region and the discussions that we're having today, for good or for bad, show that this is emphatically not the case, right? So I'm going to end by just going back to an example that I like from Colombia, like blaming the continuing inequality of Colombia on the Colombian Constitutional Court is a completely unfair assessment from any vantage point at which you look at it. Of course, the Colombian Constitutional Court is a flawed institution, and oh, I wish it would do some things different. But I would not rather live in the counterfactual. I like what it has done the last 30 years. Thank you all for being here. Thank you, Kyle.
Please thank our authors and our wonderful discussants.